Okay, well, thank you for logging on to this session and welcome. I'm Peter Hungerford Welch. I'm the Associate Dean for Postgraduate and Professional Programs at the City Law School. And my portfolio includes solicitor training, as well as barrister training and the Master of Laws programs that we offer. I'm talking today about the SQE and our response to it. I'm doing that because partly solicitor training falls within my portfolio as Associate Dean, but also because I am at the moment the Interim Programme Director for the new programme that we are developing. So this evening, I really wanted to do two things. The first is to talk about the changes which have been made to the process for becoming a solicitor with the advent of the SQE, and to tell you a little bit about what City is doing to replace our legal practice course. So those are basically the two halves. I will make sure there is time at the end for any questions, which I will obviously do my best to answer. I'm going to assume that you are unfamiliar with the detail of the SQE, so forgive me if I'm telling you things that you already know. There is a good chance there'll be other people in the room who don't already know it. So, the main change is what's different. The old system, for all its flaws, had the benefit of certainty. It was a very clear route to qualification. You did a law degree, or if you had a non-law degree, you did a GDL. You then did your legal practice course. You then did a 2-year training contract, and you were then able to call yourself a solicitor. Well, it's all different now. There is no more for solicitors a qualifying law degree or a requirement to do the GDL if you have a non-law degree. I would just add in brackets that if you're interested in becoming a barrister, we do still have the requirement of a qualifying law degree. But for those who want to be solicitors, that requirement has gone. The legal practice course is going. I'll mention in a moment transitional provisions, but the legal practice course is on its way out. Rather unusually, controversially, one might say, the Solicitors Regulation Authority doesn't require you to undertake any vocational training course before you take SQE1 and SQE2. It's what they call outcomes-based regulation. All they're interested in is students taking and passing the exams. They don't care how people prepare for those exams. So you don't have to do a vocational course at all if you don't want to. I think you'd be rather brave to do that, but that's the position as far as the regulator is concerned. Now, assuming you want to do an SQE preparation course, and I think virtually everyone will be sensible and will want to do that, you apply for a place on whatever course you've chosen via a central portal. It's the same portal which is currently used for the LPC and the GDL LawCab. However, the only reason that is still the case is that the SRA want to track the number of people who are preparing for the SQE so that they've got useful statistics on uptake of preparation programs and also to help them prepare for likely candidate numbers coming through needing to sit the assessments so they can make sure they've got enough places set up for a number of people who are going to want to take the exams. However, The course providers are not regulated by the SRA. That is a cause of potential concern because my own view, and I speak in a personal capacity, not on behalf of the university, my own view is that there is a real risk that a number of organisations will spring up purporting to offer preparation for the SQE. What they offer will in fact not be very good, but there is no regulation of that market. The SRA, won't be going in and closing down providers who are not doing what they should. Their view is that this will be dealt with by market forces. They will be publishing pass rates by provider, and they're working on the basis that if you're a rubbish provider, you won't get many people through the exam, and so potential applicants will see that your pass rate is very low and they'll go somewhere else. There are transitional provisions that I mentioned a moment ago. They're a little bit complicated, but basically, if in September of last year, you had accepted a place on a law degree or GDL, in other words, you were already in the system as a LLB student or GDL student, or indeed you have an LLB or GDL, but you've not yet gone any further in qualifying as a solicitor. In any of those situations, you can choose. You can do the LPC or the SQE. The likelihood is, and the current application rates bear this out, a lot of people are going to choose the LPC in this coming September 2020, because it is the tried and tested training program, and it is the one that firms, of course, are more familiar with. However, I don't think that effect is going to last very long. Once firms of solicitors have got their heads around the SQE regime, I think they're probably going to be encouraging their would-be trainees, employees, to do the SQE route. So I think the LPC is likely to have a very dramatic fall off in student numbers after the coming academic year, which is one reason we're not carrying on with our LPC beyond one more academic year. For those who are already in the system and really want to do the LPC, not the SQE, there will be LPC programs around at least for the next 3 or 4 years. The validations have been extended at least to 2026 for those who need it. But I think it's going to become very much a kind of minority sport. Most people, I think, will be choosing the SQE once we get to the academic year beginning in September 2023. So, what do you have to do under the SQE regime to become a solicitor? Well, first of all, you have to have a degree. It can be any subject. Remember, I mentioned a moment ago that you don't have to have a law degree or GDL. You simply have to be a graduate. That's the first thing. You then have to pass the SQE. SQE 1 deals with legal knowledge. So this is basically the knowledge components of a law degree or GDL and some of the knowledge components of the legal practice course. The assessment, which is really quite challenging, it's 2 papers, and each one is about 5 hours, so it's a bit of a marathon. It's an assessment which is multiple choice questions in a specific form, which are known as single best answer questions. Ordinary multiple choice questions, there is only one right answer, all the others are indisputably wrong. Single best answer questions, you're choosing the best answer. So what is the best advice you can give to your client? What is the court most likely to do? SQE2 is skills. I'll talk a bit about that when I'm going to talk about the programme that we're going to offer, but it's the skills which solicitors are required to possess in order to be solicitors. You have to pass the knowledge exams, SQE1, before you attempt SQE2. And that's an important qualification to remember. Pass SQE1 before you can register for SQE2. In addition to a degree and passing both SQE assessments, you have to have qualifying work experience. Now, this is a bit like the old training contract. It's 2 years, which the training contract was, 2 years in total. But unlike the training contract, it can be done in blocks, up to 4 different blocks, 4 different employers. And this is perhaps the real difference between the new system and the old. Under the old system, you couldn't start your training contract till you'd passed your LPC. Under this regime, you can do your qualifying work experience before or after the SQE assessments. So you can be clocking up some of your 2 years at an earlier stage than is currently the case. What is qualifying work experience? The SRA have been rather reticent in defining it. They said it requires the provision of legal skills. So you have to have a role, paid or unpaid, in which you are providing legal services. In other words, exercising some of the skills that a solicitor would exercise. You have to display, they say, at least 2 of the required competencies. I'll tell you what they are in a moment. So it is doing some, if not all, of the sort of things that solicitors do. It is signed off by a solicitor. Now, this qualifying work experience doesn't have to be done in the UK. It can be done overseas, but it has to be signed off by someone who is on the roll of solicitors of England and Wales. And to sign off, they have to be sufficiently familiar with your work to be able to say that you have displayed those competencies. The guidance from the SRA makes it clear that they're not appraising the quality of what you've done. So they're not assessing you. They're simply saying that the roles you have done have enabled you to display at least 2 of those competencies, and that there haven't been major problems. You haven't had lots of complaints against you. The 4th requirement, so we've got degree, pass the SQE, qualifying work experience. The other is you have to satisfy the SRA character and suitability requirements. One of those requires you to do a disclosure and barring service check, criminal records check. So those are the elements. Once you've ticked those 4 boxes, you're then entitled to call yourself a solicitor, or putting it in more formal language, you are admitted to the role of solicitors. I mentioned the 4 competencies. They're under 4 very broad headings. There's a lot of text under each of these headings. I thought it would bore you beyond endurance if I shared any of that text with you. So I thought I would just stop at the headings. But these are the headings for the competencies they're looking for. So you've got ethics and professionalism. You've got the technicalities of legal practice. So that's all to do with running litigation, drafting, and all that sort of thing. The soft skills, working with colleagues, working with clients, able to deal with difficult people, all that sort of thing, and self-management that is necessary for someone to be an effective solicitor. So those are the broad headings. And so the qualifying work experience, you're going to have to be able to show that you've been doing things which tick the boxes under at least two of those four headings. So what are we doing about it at City Law School? Well, the first thing we decided to do was to talk to firms of solicitors to find out what their thinking is about the new SQE regime. It has to be said there is some nervousness amongst practitioners. There is concern that having a regime in which all the applicant has to do is pass the exams and demonstrate knowledge that way may not necessarily give those applicants the depth of knowledge and the level of skills which are going to make them a useful employee from day one. A number of people have used the expression oven ready. They say they want their trainees oven ready. So a lot of firms that we've spoken to have said when they're deciding who to interview and then possibly take on as employees, they are going to be giving preference to those who have a law degree or GDL. I should say a lot of solicitors firms do like non-law graduates because quite often a non-law graduate has a more rounded approach than someone whose focus has always been law. I was boring. I went down the LLB and then qualified as a barrister route, so totally law focused. And I entirely take the point that I would have been a more rounded junior lawyer had I had a non-law degree and then done the GDL. But firms are really concerned that just preparing for SQE1 isn't going to give you the depth of knowledge that you're going to need to be effective as soon as you join the firm. And I have to say good news for City Law School. Firms said they would certainly be looking with favour on people who've done an SQE programme that leads to an academic qualification, because again, that will suggest a degree of rigour about the training and that it really is worth something. It might just be worth me saying at this point that I think in broad terms, two types of preparation programme are emerging in the market. There are those training providers who simply offer SQE preparation. No qualification at the end of it, simply preparing you for the exam. And obviously within that group of providers, there'll be some who are really good and some who are frankly not so good. But the other type of provider will be those who offer an academic qualification as well. It's a little bit simplistic, but I think the market is going to divide into university providers and non-university providers. Obviously, in my position within City University of London, we're in the business of giving people academic qualifications. Well, we don't give them, you have to work for them, but we're in the business of awarding academic qualifications. And so it would be rather odd if we were offering a programme which wasn't doing that. So, in the hope that you're interested in what we will be offering from September of 2023, we are calling it the Solicitors Practice Programme because that's exactly what it's preparing you for, practice as a solicitor. It is obviously aimed primarily to help you prepare for the SQE, but also to help you become a practitioner. So we're taking a broader view than simply getting people through exams. For example, SQE1, the knowledge exam, well, that kind of lends itself to rote learning, just memorizing stuff without fully understanding it. That does not a good lawyer make. So we are very much focusing on teaching these subjects in a way that is going to help people become good lawyers. Our program has two, or will have two exit points. You can just do the postgraduate diploma route. This is two 10-week terms. Term 1 is preparation for SQE1, and term 2 is preparation for SQE2, with, as I've said, the practice focus. And if that's all you want, you can depart at that point with your postgraduate diploma and obviously pass the SQE exams as well. Alternatively, you can stay with us. And if you're on the Master of Laws route, as well as doing the SQE1 and SQE2 terms, you have an additional 5-week term where you do 2 electives. And you also do a research project connected to legal practice. I'll say a bit more about that in a moment. But the thing perhaps I would want to emphasize is that the way we are designing both the curriculum and the add-ons, the extracurricular activities, the events and the other opportunities which are open to students, very much focus on making you employable. So getting stuff on your CV, which is going to encourage a firm of solicitors to say, yes, this person's worth interviewing. And then to give you stuff you can talk about in your interview, so that they say, yes, we want you to join our firm. We are writing the program now. It is launched in September of 2023, at which point our legal practice course will have terminated. So we're offering the LPC once more, and that is in the academic year, which starts this September. Thereafter, we will not be offering the LPC. My guess is that student numbers will be sufficiently low at that point for the LPC that it wouldn't be economically viable. And I am keen that we focus on the future of solicitor training rather than the past. And so we're going to be going all guns blazing September 2023 with the SQE. So unpacking that a little bit, and this will also tell you a little bit more about what the SQE contains. Term 1, that's preparing you for SQE1 and for SQE1. SQE1 is divided, as I mentioned, into 2 exams. Functioning Legal Knowledge 1 and Functioning Legal Knowledge 2. I don't like those titles. And Functioning Legal Knowledge, what's that? So we're calling our modules Professional Legal Knowledge, but it's just a label. The content is as per the SRA exam specification. So PLK1 is business law, dispute resolution, contract, tort, English legal system, constitutional administrative law, EU law, if that still exists. There's a debate about that, which we won't go into, and the law relating to provision of legal services. PLK2, property law, wills, solicitors' accounts, unending fun there, landlord trusts and crime. You may think, well, those mixtures look a bit odd. Given a free hand, I might want to move the bits about a little bit, but these are the topics which are covered in the 2 SQE1 exams, and the division is exactly what you can see on the slide. So obviously our modules have to reflect that division of knowledge, but it is, as I mentioned earlier, a mixture of undergraduate law, contract, tort, English legal system, with LPC knowledge, business law, property law and practice, accounts. For the program we're offering, for each of these modules, you have two 2-hour tutorials per week. It's a blended learning program, so a lot of the work will be based on online resources, and the face-to-face tutorials, 2 per week per module, are building on the work that you've done using the online resources. So that's term 1. Term 2 is SQE2, which has 4 components to it. Interpersonal professional skills, so that's advocacy, primarily making submissions to the court and questioning witnesses, and client interviewing, giving clients advice orally, face-to-face. Analytical professional skills, well, that encompasses case analysis, so that's what in some jurisdictions is called fact management, but working out what the case is really about. Legal analysis and legal research, so making sure you know what law to look for, being able to find that law and being able to apply that law. The written skills is legal writing, so that includes letters to clients, letters to other professionals, letters to your opponent, if it's contentious work, and drafting, particularly drafting legal documents, but more broadly than that. And a module that we've called Preparing for Practice. In the SQE, they have what they call pervasive subjects. We've taken those pervasive subjects and we've turned them into a module which looks at the professional side, including conduct and ethics, financial services, the rules about money laundering. That's really important for solicitors. It involves things like making sure you know who your client really is. That's why if you go and see a solicitor as a client, the first thing they'll want to do is to see your evidence of identity and address. They have to do that because of the anti-money laundering regulations. So term 2 is going to be 4 modules, the 3 SQE2 assessments and the pervasive subjects, a 2-hour tutorial per week for each of them. Again, blended learning, so lots of stuff online that you're then using in your face-to-face tutorials. If you've done the maths, you will have noticed that's 8 hours of class contact per week. But I should warn you, there'll be a lot of work to do outside the classroom. If you are staying on for the full master's degree, I mentioned you would do 2 electives, choosing any 2 from this list. We're starting modestly. We don't want to bite off more than we could chew. We are writing a new program. And so we're going to start with 6 electives. My plan is that that list grows year by year once we've got the basic program up and running. But this is our opening bid. So for September 2023, these are the electives we are planning to offer. Choose any 2 of those and same workload, 2-hour tutorials per elective. And if you're on the master's route, the other thing you'll be doing is this legal practice research project. Now, that's defined very, very broadly. It is doing things which are relevant to legal practice. So it could, for example, be doing some pro bono work and writing that up. It could be, for example, researching current thinking into legal tech and writing that up into a project report. We decided not to go down the road of a traditional academic dissertation, But the point of the research project is it's the equivalent of a dissertation. So you're demonstrating abilities to analyze and to synthesize at a level appropriate to a master's degree. One thing to be clear on, because with this new regime, it's quite complicated. You've got lots of choice and lots of ambiguity. I do want to just clarify the relationship between the SQE assessments and our city assessments. In order to be a solicitor, the key thing is to pass SQE1 and SQE2. The fact that you pass our assessments does not tick that box. You still have to pass SQE1 and SQE2, even if you've passed our assessments with a distinction. However, the other side of the coin is, as a university, we can't give credit for you passing SQE1 and SQE2. You have to pass our assessments. So to get the university qualification, you have to pass our modules. I appreciate that that creates the downside that you have two sets of exams to look forward to. Perhaps look forward is not the right expression, but you know what I mean. The SQE assessments and City's own assessments. The motivation for doing that, I mentioned earlier, firms suggesting to us that they would give preference to people who've got an academic qualification as part of their SQE preparation. Passing SQE1 and SQE2 doesn't give you letters after your name, whereas if you pass a university qualification, you do get some letters after your name. And that can be important when it comes to job hunting. Something else I need to emphasize is that we have designed or are designing our program on the basis that our students will have a law degree or a GDL. Now, of course, that means that we are kind of defining our place in the market quite clearly. We took that decision because of the market research, which suggested that firms are really going to prefer students who've got an undergraduate law degree or a GDL, as well as an academic qualification arising from their SQE preparation. And so we are working on the basis of employability, and we are therefore limiting our intake to people who have already ticked one of those employability boxes with a law degree or a GDL. We are imposing an English language requirement, partly because of the difficulty of the SQE assessments. Both SQE1 and SQE2 require a very high level of facility in English language. And frankly, we don't want to be taking people on who are likely to have real difficulties passing the SQE, never mind our own city exams. In terms of cost, the market, if you research providers, the market is kind of settling down with a degree of similarity regarding course fees. The fees that we have fixed for the PG DIP and the Master of Laws degree are not dissimilar to those of other universities providing something which on paper looks not dissimilar to what we're offering. If you sign up for the LLM route, then you are eligible, if you're a UK student, for a postgraduate student loan. City does offer scholarships. For September 2023, the amounts of the scholarships are, as I've put on the slide. We offer an automatic fee waiver if you have a first-class undergraduate degree. And there is then the possibility of a partial fee waiver, irrespective of class of degree, on the basis of academic excellence. And across our postgraduate and professional programs, we have a total of 10 full fee scholarships, and we make sure that at least one of those goes to each program. To note, you have to make your own arrangement to sit the SQE. You have to create a My SRA account, and you have to register with the SRA, and you have to pay them an assessment fee. It's different amounts for SQE 1 and SQE 2, but this year the grand total was £3,980. You will see from this that the SRA's hope that abolishing the LPC would reduce the cost of legal training is an aspiration which is not going to be fulfilled. Some of us never thought it would be fulfilled, but that I'm afraid is the harsh reality. Okay, well, we've run out of slides, and I said I would leave some time at the end for questions, so I am going to stop sharing my screen, and I'm going to invite questions. I think in terms of asking the questions, you're welcome if you wish to put questions in the chat, if you prefer just to type them. Alternatively, and perhaps it would be nicer for everyone if you turn your camera on and unmute yourself and speak your question, and I will try to do my best to answer it. So, any questions?
Thank you very much for that presentation, Peter. I'll kick the questions off just in case. Oh, actually, there's someone else who has a question here. Do you know how people normally fund the course if not doing the LLM route? From Eloise Kimber.
Yes, thank you for that question. We're in uncharted territory to the extent that SQE preparation courses are only just getting started, and indeed ours isn't going to start until September 2023. So normal funding for this particular form of training, we are very much in uncertain territory. I have had conversations with a number of firms, as I mentioned, and putting to one side the SRA's position that you can do qualifying work experience whenever, you can do it before or after passing the SQE. The firms I've spoken to, and I've organised an advisory panel. It's got over a dozen firms on it, not just London, and various sizes from medium to large firms. And a lot of them, though not all of them, are saying they're basically going to want students to have passed their SQE before they take them on to the staff. So the firms, I think, are really going to try and keep the idea of a training contract. It's not what the SRA intended, but the firms are the employers. And the upside of that is a lot of firms will be sponsoring people through their preparation course. I don't think, well, some firms will sponsor for the full master's degree, but if you're a UK student, you do have the possibility of a PG student loan for that. But I think a lot of firms will be sponsoring people to do the SQE 1 and SQE 2 preparation. So that is a potentially good source of funding. Otherwise, I'm afraid it is probably things like career development loans. There are a number of organisations who specialise in career development loans, particularly with repayment terms, which are linked to the the practice you'll be going into. So understanding that you won't be in a position to start repaying any of it until you've got a job, basically. Interesting question from Latoya. If someone's already done the LPC but wants to pursue the qualifying work experience with a view to doing the SQE as now this is this is an interesting one. I think I'm going to have to say, why would you? Why would you want to do another set of exams? I think if you have passed the LPC, you would be much better off just doing your training contract under the old regime. Qualifying work experience is broader than a training contract, but a training contract kind of is qualifying work experience. So my suggestion would be think long and hard before putting yourself through another set of exams if you've already passed the LPC and are therefore eligible to take up a training contract under the old regime. If I broaden that question out just a little bit, I don't know, this may or may not apply to anyone in this virtual room, but there may be people who are qualified lawyers in another jurisdiction. Now, if that's the case, then it's a slightly different answer, because potentially you can get some exemptions from at least some of the SQE exams. The old qualified lawyers transfer test, QLTS, that you may or may not have heard of, has been abolished, so that's gone. Unless you're already embarked on the QLTS, forget it, it's gone, it's not open to new applicants. So if you're an international lawyer, in other words, you're qualified in another jurisdiction and want to be a solicitor in England and Wales, then what you need to do is to contact the SRA, set out what your role is and what you've done, and ask them what exemptions they're prepared to give you. So I hope that answers that question. Rochelle asking for a bit more detail about the legal practice research project and what it would entail. Very good question. I was quite vague on that. And I was vague on that because it is still a work in progress. My intention is that we are as flexible as possible. One of the things we are looking at, I'm having conversations with various pro bono partners who may well be able to accommodate a system where the research that you're doing is based on pro bono work that you are involved with. We do something similar on one of our other programs, so I'm not being particularly heretical by suggesting that. But equally, it could be more traditional library-based research, but on something which is relevant to legal practice. We have intentionally, in all the documentation which is going through the approval process, kept it as vague as we can because we want it to be flexible. What you need to demonstrate in that research project is the ability to analyze critically, which in turn requires you to synthesize information, process that information, analyze it critically, and produce an extended piece of writing where you are demonstrating the outputs from that, up to 10,000 words. It gets you, if anyone's familiar with the credit system in higher education, it's a 30-credit module, so a fairly significant piece of work. But it's demonstrating an ability to write a critical piece of some length. The area in which you are writing, we're intentionally keeping it broad. It will need to be something that we're able to supervise, so it can't be too off the wall, but we want to be as flexible as possible. So I'm sorry that's a rather vague answer, but this is a work in progress, and our thinking, the development team that I chair, and my own personal thinking on this is still developing. But my watchword is keeping it flexible. But my other watchword is employability, and I am determined that the skills you're demonstrating in your research project are highly relevant to employment. I mentioned when I was talking about it, a research project based on legal tech. I haven't really thought that through to its logical conclusion, but obviously legal tech is becoming increasingly important. It's a work in progress for the profession, and so there is plenty of stuff one can think about and write about in that particular space. So flexible, relevant to employment, those are key things. Caitlin, you've got your hand up. So if you would like to ask a question.
Hi.
Hello.
Yes, I just wanted to ask, so I don't know if this is still the position, it sounds like it's not, but in our induction lecture, I think James Catchpole mentioned that since we were the last year to have the choice between the LPC and the SQE, he would kind of suggest the sort of tried and tested route. My plan had been to take a year out and do some paralegal work after the GDL, by which point obviously City will no longer be offering the LPC. And I wondered if that was kind of going to be the situation across the board, if all universities are phasing out the LPC after just 1 year, or if some will still kind of provide it, or, I mean, I guess that's something you might not be able to say, but.
I can't answer with certainty because I'm not privy to the detail of what other universities are doing. I am sure there will still be LPCs around in September 2023. I think I mentioned that the SRA have extended validations up to at least 2026 to accommodate those people who are kind of in the system and really want to do an LPC, but the number of available LPCs will go down. I think probably September 23, there will probably still be a reasonable choice for you. 2024, I think, this is just a guess, but my prediction is that student numbers for the LPC will plummet, and a lot of providers are going to say, look, it's not financially worth doing this. And so the number will, I think, drop off, really quite rapidly. The graph is going to go downhill, really quite steeply. But yeah, if you really want to do the LPC, then there will be LPCs you can do in 2024 or 2023. But I did think about, should we try and offer both at the same time, but that does obviously present a strain on the system. And my prediction is that numbers will have gone down sufficiently on the LPC that it's better to focus our efforts on the new programme.
Thank you.
And the SQE is going to be enormous fun. Sharon asks about QW, qualifying work experience. Yes, blocking it in that way is entirely possible. As far as the SRA are concerned, so long as you have done a total of 2 years full-time or full-time equivalent, and I'll just put a footnote in there, the SRA have refused to define what is full-time or full-time equivalent. They have said it is up to the solicitor who signs off your QWE. as a footnote of the footnote, I think that puts an enormous pressure on the solicitor who's signing it off. And my own personal view is there should be more guidance. Though, of course, that then runs the risk of becoming too rigid. I did raise this with the Law Society, the representational body for solicitors. Although I was qualified as a barrister, I actually am a member of the Criminal Law Committee on the Law Society. And I did raise in that forum whether the society ought to be lobbying for a clearer definition to help those who would sign off. But there didn't seem much enthusiasm for that. So the supervising solicitor signs off whether it's 2 years full-time or full-time equivalent. It can be done in a total of no more than 4 different organizations, which we talk about the 4 blocks, but those blocks don't have to be equal size. You could theoretically do 2 months, 8 months, and then my maths is going to let me down here, but divide the other bit equally. But it is possible there will be people who have perhaps been paralegaling for a few years, who have effectively done their QWE already. Get a solicitor to sign it off, job done. You've ticked that box. The firms I've spoken to, not all of them, but most of them have said, well, yeah, people might have done their QWE, but we're going to want them to be doing it in our firm. So I think there will be firms who will, whatever your pre-existing QWE record is, they're going to want you to be on their 2-year training program. The larger firms have very well thought out programs for how they deal with trainees in that 2-year period, quite often rotating you around various seats, as they're called, within the firm. So you're working in different departments, and so getting a broader view of what the firm does, even if you want, you really know which department you want to work in. They want you to see how the others go. And the firms I've spoken to, most of them say, well, we're still going to want people to do that before we are happy to take them on a permanent basis. So I think there is going to be there's going to be a bit of inconsistency between the 2 years that you have to clock up to satisfy the QWE thing, so that you've ticked that box to become a solicitor, and what firms are asking you to participate in. So, sorry, this is a bit convoluted, but you may well find that you end up doing a bit more than 2 years QWE, because you've already got some to your record, which the SRA will recognise, but the firm you go to say, no, we want you on our 2-year trainee programme, so that we can make sure we've done everything that we want. Eve Mary, about part-time work experience. Yeah, the Law Society, not Law Society, the SRA have clarified this a bit. They initially said 2 years, 2 years full stop. They've now clarified that what they meant was 2 years FTE, or full-time equivalent. So you could do your 2 years part-time over 4 years. So if you're working half a week in your QWE, you'd have to do that for 4 years, so that you've got the equivalent of 2 years full-time. But so yes, there is an option for part-time, but the bottom line is that the solicitor who signs you off has to say, I am satisfied this person has done 2 years full-time equivalent. Okay, Rochelle, you've got your hand up. I'm not sure if that related to an earlier question or if it's a new question.
No, sorry, it's a new question.
Oh, okay.
With regards to qualifying work experience, is there a preference from firms as to what these roles should be? As in, for example, would a paid role be more preferable than a volunteer one, or is there anything along those lines?
What they are most concerned with is that you are doing stuff which will be relevant to what you'll be doing with them. So they're not fussed as to whether it's paid or unpaid. What they are concerned with is that you are demonstrating the ability to do the sort of things that you're going to need to do when you're an employee of that firm. Thinking of it, and this might help or not, but what firms are looking for, and I'm going to use the word trainee. It's kind of old-fashioned because they're very inflexible training contract, but I mean new members of staff who are on a 2-year integration training program within the firm. So I use trainee for short. A firm wants the trainee to be doing useful stuff from day one. Firms don't have trainees sitting in classrooms for 2 years. From day one, you're going to be helping clients. You're going to be helping fee earners earn fees. And so, they want people who can hit the ground running. And so when you're making applications to firms, they want to get a feel for the things that you have done, which are going to mean that you can hit the ground running when you join them. They're not. My last meeting with the advisory panel, they were saying we're not looking for a load of clones. We're looking for people who stand out from other applicants because they've done things which are really relevant to the sort of skills they're going to have to be using if they come to our firm. So you really think about what can I be doing within the legal services sector. And for it to count as QW, it has to be the provision of legal services. But so long as you are involved in the provision of legal services and demonstrating at least 2 of those competencies, you might want to go onto the SRA website and look at the text under those broad headings I gave you, because that'll give you a feel for the sort of things that they're looking for something to be QWE. But in terms of employability, it's what have you done which is going to make you able to do useful work from day one.
Thank you.
Okay. Any more for any more? I think the well of questions might now be empty. What I have done is I've put my email address in the chat. If you're anything like me, you'll leave the meeting and 30 seconds afterwards you'll think, do you know, I've just thought of a really good question I should have asked. If you think of such a question, please do drop me an email and I will do my best to respond to it. But I think on the basis we've now just gone over the hour, and you may well have other plans this evening, I don't know. I think we can probably draw the session to a close now. Thank you for listening patiently to my exposition of what is really quite a complicated subject, the SQE. It brings flexibility, but with flexibility becomes a kind of excess of choice. There are lots of decisions that students have to take. Am I going to do a law degree? Should I do a non-law degree in a GDL? What sort of SQE course should I do, etc., etc. I am working on I'm calling it a decision-making document, which I'm going to get put on our website, offering guidance depends on the questions you need to be asking yourselves and the factors that you need to bear in mind when you're answering those questions. But I do not underestimate the complexity of these new arrangements and the uncertainty which they bring.